Mr. President, today we'll continue to debate the nomination of Judge Neil M. Gorsuch to serve as Associate Justice of the Supreme Court of the United States. The Judiciary Committee held 4 full days of hearings last month. The judge testified for more than 20 hours. He answered more than 1,000 questions during his testimony and hundreds more questions for the record. We've had the opportunity to review 2,700 cases that he's heard, and we've had the opportunity to review the more than 180,000 pages of documents produced by the Bush Library and the Department of Justice. Now, after all of this, my Democrat colleagues unfortunately appear to remain committed to what they've been talking about for a long period of time, filibustering the nomination of this very well-qualified jurist. Even after all this process, there's no attack against the judge that sticks. In fact, it's been clear since before the judge was nominated that some members in the Democratic leadership would search desperately for a reason to oppose him. As the minority leader said before the nomination, and I quote him, "It's hard for me to imagine a nominee that Donald Trump would choose that would get Republican support that we could support," end of quote from the minority leader. He said later, and I continue to quote him, "If the nominee is out of the mainstream, we'll do our best to hold the seat open," end of quote. But then the president nominated Judge Gorsuch. This judge is eminently qualified to fill Justice Scalia's seat on the Supreme Court, and there's no denying that whatsoever. So let me tell you something about him. A graduate of Columbia University and Harvard Law School, he earned a doctorate in philosophy from Oxford University and served as a law clerk for 2 Supreme Court justices. During a decade in private practice, he earned a reputation as a distinguished lawyer and appellate judge, both trial and appellate judge. He served with distinction in the Department of Justice. He was confirmed to the 10th Circuit Court of Appeals by this body unanimously, voice vote. And the records he's built during his decade on the bench has earned him the universal respect of his colleagues, both on the bench and the bar. This judge is eminently qualified to do what the president appointed him to do. Now, faced with an unquestionably qualified nominee, my friends on the other side of the aisle, my Democrat colleagues, have continually moved the goalposts, setting test after test for this judge to meet. But you know what? This judge has passed all of those tests, all with flying colors. So, the people on the other side of the aisle, our Democratic majority, are left with a no vote in search of a reason. So let's go through some of their arguments. First, the minority leader announced that the nominee must prove himself to be a mainstream judge. Now, is he a mainstream judge or not? Well, you consider his record. Judge Gorsuch has heard 2,700 cases, written 240 published opinions. He's voted with the majority in 99% of the cases, and 97% of the cases that he's heard have been decided unanimously. Only one of those 2,700 cases was ever reversed by the Supreme Court, and it happens that Judge Gorsuch did not write the opinion. Then consider what others say about him. He's been endorsed by prominent Democratic members of the Supreme Court bar, including Neil Katyal, President Obama's acting Solicitor General. This acting Solicitor General wrote a New York Times op-ed entitled, quote unquote, "Why Liberals Should Back Neil Gorsuch." Mr. Katyal wrote, quote, "I have no doubt that if confirmed, Judge Gorsuch would help to restore confidence in the rule of law." End of that quote. He went on to write that the judge's record, quote, "should give the American people confidence that he will not compromise principle to favor the president who appointed him," end of quote. There's another well-known person, likewise David Frederick, board member of the Liberal American Constitution Society, says we should, quote, "applaud such independence of mind and spirit in a Supreme Court nominee," end of quote. So, after hearing both what people on the right and the left have said about the judge, he is mainstream. But the goalpost seems to move. Next, we hear that the judge doesn't care about the little guy and instead rules for the big guy. Now, first of all, that's a goofy argument. Just as liberal law professor Noah Feldman, he says, if you ask Professor Feldman, he says, this criticism is a, quote unquote, truly terrible idea because, continuing to quote, "the rule of law isn't liberal or conservative, and it should not be," end of quote. The strategy on this point became clear during our hearing. Pour through 2,700 cases, cherry pick a couple where sympathetic plaintiffs were on the losing end of the legal argument, and then find a reason to attack the judge for that result, and then because of that case or two, label him, quote unquote, against the little guy. Now, as silly as that argument is, the judge himself laid waste to that argument during the hearing when he rattled off a number of cases where the so-called little guy came out on the winning end of the legal arguments of a case. At any rate, as we discussed at length during his hearings, that the judge applies the law neutrally to every party before him, and that's what you expect of judges. I disagreed with some of my colleagues who've argued that judging is not just a matter of applying neutral principles. I think that view is inconsistent with the role of our judges and the role they play in our system and more importantly, in regard to the oath that they take. That oath requires them to do, quote, equal right to the poor and the rich, and to apply the law, continuing to quote, without respect to persons. Now, naturally, this is what it means to live under the rule of law. And this is what our nominee has done during his decade on the bench of the 10th Circuit Court of Appeals. So the judge applies the law, quote unquote, without respect to persons, as he promised in his first oath he would, and he'll repeat in the oath when he goes on the Supreme Court. And then, of course, the judge, as they move these goalposts, the judge has been criticized for the work he did on behalf of his former client. And that former client was the United States government when he was in the Justice Department. Of course, we've had a lot of nominees over many years who had worked as lawyers in the government. Most recently, Justice Kagan worked as Solicitor General. As we all know, she argued before the Supreme Court that the government could constitutionally ban pamphlet materials. Now, that's a fairly radical position for the United States government to take. So, we are asked about, when asked about the argument during her hearing, this is her answer. She said she was a government lawyer making an argument on behalf of her client. That's the United States government. And it had nothing to do with her personal views on the subject. But now there's a whole different standard for some people of this body. The answer is apparently no longer good enough. Now, to hear the other side tell it, government lawyers are responsible for the positions that their client, the United States government, takes, and a position that they have to argue. I respect my colleagues who are making this argument, but this argument does not hold water. What then are my colleagues on the other side left with after moving these goalposts many times, after making all of these arguments that don't stick? What are they left with? Because they can't get any of their attacks on the judge to stick, all they're left with are complaints about the so-called dark money being spent by advocacy groups. Yes, that's where the goalposts took them, to dark money. As I said yesterday, that all speaks volumes about the nominee, that after reviewing 2,700 cases, roughly 180,000 pages of documents from the Department of Justice and the George W. Bush Library, thousands of pages of briefs, and over 20 hours of testimony before our committee, and hundreds of questions, both during and after the hearing. All his detractors are left with is an attack on the nominee's supporters, people out there that probably the nominee doesn't even know. And they raise money to tell people about him, which they have a constitutional right to do under the First Amendment, freedom of speech. The bottom line is that they don't have any substantive attacks on this nominee that will stick. So they've shifted tactics yet again, moving the goalposts, and are now trying to intimidate and silence those who are speaking out and making their voices heard in regard to this nominee. But here is the most interesting thing about this latest development. there are advocacy groups on every side of this nomination. There's people out there for him and raising money and spending the money for him, and there's people out there against him, raising and spending money so people know why they disagree with this nominees. And, of course, that's nothing new. That's been true of past nominations. And there's nothing wrong with citizens engaging in the First Amendment freedom of speech and in the process of being for or against and encouraging public debate of whether a person ought to be on the Supreme Court or not be on the Supreme Court. Now, it was certainly true when liberal groups favoring the Garland nomination poured money into Iowa to attack me last year for not holding a hearing. For that reason, I didn't hear a lot of my Democratic colleagues complain about that money that could well be called dark money as well. And of course, there are groups on the left who are running ads in opposition to this nominee and threatening primaries. They're actually threatening primaries against Democrats who might not toe the line and might not help filibuster this nomination. For some reason, I'm not hearing a lot of complaints about the money that's being raised to make some Democrats that might support this nominee look bad. And as I've said, there's nothing wrong with citizens engaging in the process and making their voices heard. This is one of the ways that we're free to speak our mind in a democracy. It's been true for a long, long time. As I said yesterday in the committee meeting, if you don't like outside groups getting involved, the remedy is not to intimidate and try to silence that message. The remedy you ought to follow is to support nominees who apply the law as it was written, and then in turn leave the legislating to a body elected to make laws under our Constitution, the Senate and House of Representatives. But regardless of what you think about advocacy groups, about them, they're getting involved, there's certainly no reason that they should go to great lengths to talk about this in our committee or talk about it to the nominee, because he can't control any of that. The truth of the matter is that Democrats have no principled reason to oppose this nomination, and those are words from David Frederick that I've quoted before. It's clear instead that much of the opposition to the nominee is pretextual. The merits and qualifications of the nominee apparently no longer matter. The only conclusion that we're left to draw is that the Democrats will refuse to confirm then any nominee that this Republican president may put forth. There's no reason to think the Democrats would confirm any other judge the president identified as a potential nominee or any judge that he'd nominate. In fact, we don't even need to speculate on that point, because the minority leader has spoken to that point and made his point very clear. He said before the president made this nomination, and I want to quote him one sentence, "I can't imagine us supporting anyone from his list," end of quote. So it was very clear from the very beginning that the minority leader was going to lead this unprecedented filibuster. The only question was what excuse he would manufacture to justify it. The nominee enjoys broad bipartisan support from those who know him, and he enjoys bipartisan support in the Senate. I recognize that the minority leader is under very enormous pressure from special interest groups to take this abnormal step of filibustering a judge, because filibustering in the Senate is not unusual, but filibustering a Supreme Court judge is very unusual. And I know other members of his caucus are operating under those very same pressures as well. In fact, yesterday, while the committee was debating the nomination, a whole host of liberal and progressive groups held a press conference outside of the Democratic Senatorial Campaign Committee demanding that the campaign arm cut off campaign funds for any incumbent Democrat who doesn't filibuster this nominee. Those groups argued that because the Democratic Senatorial Campaign Committee had already raised a lot of money off the minority leader's announcement that he was going to lead a filibuster, that committee shouldn't provide that money to any member who refused to join this misguided effort. Well, all I can say is that it would be truly unfortunate for Democrats to buckle to that pressure and engage in the first partisan filibuster of a Supreme Court justice nominee in U.S. history. Another way to say that is the first partisan filibuster in the 228-year history of our country since 1789. If they regard this nominee as the first in our history worthy of a partisan filibuster, it's clear they would filibuster anyone. But I've said since long before the election that the new president would nominate the next justice and that the Judiciary Committee would process that nomination. That's just what we've done through the committee, and now we're doing on the floor. So I urge my colleagues not to engage in this unprecedented partisan demonstration. Everyone knows the nominee is a qualified, mainstream, independent judge of the very highest caliber. Republicans know it, Democrats know it, and the left-leaning editorial boards across the country prove even the press knows it. So I urge my colleagues on the other side to come to their senses and not engage in the first partisan filibuster in U.S. history, and instead join me and vote in favor of Judge Gorsuch's confirmation. I yield the floor.